in the past week, the National Assembly debated two pieces of legislation affecting South Africa's bloated public service, the Public Service Amendment Bill and the Public Administration Management Amendment Bill, and the Statistics Amendment Bill were passed at the National Assembly's hybrid plenary sitting. One expert has lauded the Public Service Amendment Bill, calling it one of the most important reforms from the South African government since 1994. New South Institute's Executive Director, Dr. Ivor Chipkin, is now joining us this morning. Dr. Chipkin, good morning. Thank you so much for making time for us.
Good morning. It's nice to be here. Thank you.
Before we get into the purpose of the bill and what the bill is trying to fix or trying to provide a solution to, do you foresee any challenges to the bill, constitutional challenges at that as well, considering what the municipal management bill went through as well, through Parliament?
I don't at this stage, not in its current form. Public Service Amendment Bill deals with national and provincial officials. It doesn't deal with municipalities, so there's no contradiction or tension with the MFMA that I understand, that I can see. So I don't.
Yep.
That's the simple answer to your question.
And the reason that I asked this question, Dr. Chipkin, is because with the Municipal Systems Act, it was challenged because of that legislation that said that municipal workers cannot be part of political parties. But as the Minister of Public Service and Administration has said, what this bill really does, when it looks, for instance, at the head of departments, it just says that a head of department cannot be a senior leader in a political party, so can't have a senior post in their political party.
Mm. So our constitution is pretty vague in this regard. All the constitution says is that, and the wording, if I can remember it correctly, is confusing. It says that no one can discriminate against anybody for being a member of a political party. So it doesn't outrightly ban membership of a political party in the public service, which is unusual by international standards. So what that non-discrimination clause actually refers to is that anybody can be a member of a political party in the public service, but that they cannot, I think this is how it's currently being interpreted by the courts, is that they cannot carry, or that this is how it's being interpreted by this piece of legislation, they cannot carry a party political mandate as a public service. So they can be a member of a political party, but their membership of the political party stops at the door of their public service office. So, and I think so that the beginnings of a distinction between public office and political office, which is being entered, and I think that distinction is absolutely fundamental to the modernization of the state. So it's very subtle. The amendment to the bill, I think, goes quite far in making it not so subtle in some areas. But it's that distinction which is absolutely the fundamental breakthrough which is taking place this week.
Yeah. And speaking about, for instance, if you look at the infamous Broederbord that you make reference to in one of your opinion pieces, what do you think, or how far do you think this legislation goes in terms of trying to insulate the state from party political mandates?
So I think it goes far, and this is why I'm excited about it. Partly because it essentially prevents or stops politicians, the president, members of ministers, cabinet ministers, and MECs at provincial government level from exercising discretion in two areas, which they currently have the rights to, not by in law through the Public Service Act. They currently, in Section 3 of the Act, they have the right in law to preside, have discretion over all appointments in the public service, which is quite incredible. So all our public servants are, in principle and by law, they are political appointments, unless the minister or the president or an MEC delegates those authorities down to a senior official. And of course, it's that delegation struggle that has been at the heart of so much chaos and the contestation within the public service in South Africa. What the National Development Plan euphemistically called, I think they call the tensions in the political administrative interface. It's a real sort of flowery language to describe this kind of very, very fierce contestation that's been happening between ministers and director generals. So it goes some way to resolve those tensions by deciding in favor of director generals and heads of department. So for the first time ever, actually, Director Generals and heads of departments will have the authority and the autonomy to make appointments of public servants without ministerial interference. And I think that's a huge, huge breakthrough. The second huge area is that in the current legislative environment, ministers have the discretion to interfere in operational decisions in departments. So you're a Director General, you're a head of department, you are responsible for developing the operational model for your department, how it works, etc., how it's structured, etc. But you can't appoint staff, and also you can't make final decisions on those operational decisions around how to work. That's all beginning to change now with this amendment. So it's giving power to the officials. Yeah. Of course, and we can discuss that in a moment. That raises very profound questions about who those officials are and how they are appointed. For the moment, it resolved a deep and fundamental contradiction within our departments.
Yeah, and that's the issue, because before the debate has also been that the president is perceived, if we just focus, for instance, on the executive at a national level, is that the president has too much power, and time again, even with when you question the president around appointments and so forth, you are told that the president is exercising his discretion, which is allowed in law. And yes, you can go and challenge the appointments that has been made by the president on the basis of rationality. But what about just on right at the forefront, saying that this is the level of transparency that is required, but also dealing with the powers of the president?
Yeah. So, I mean, we've just finished a piece of work, myself, Michelle Leroux, and my colleague Rafael Leite, and we looked at all the legislation regarding the criteria for appointments at all senior positions in key departments, whether it's the police, whether it's SARS, Director Generals in key departments, whatever it may be. And what is astonishing is to find, and go and have a look at yourself, you'll be amazed, there are almost no criteria for those appointments. In other words, if you're the Commissioner of Police, for example, all that it requires is you don't have a criminal record. You don't have to have had any experience in the police. You have to have no courses in criminology or anything like that. And what it allows for in the current situation, therefore, is very, very wide discretion of politicians to appoint people into the public service. So what we've been arguing is that the problem is not cadre deployment. Cadre deployment is a symptom of a legal problem. And the legal problem is that underpinning our public service is a legal framework which allows politicians to appoint public servants. And I think that is at the heart of the problem. So the fact that the ANC's cadre deployment policy can issue an instruction to a minister to appoint so-and-so into a key department, the ability of the minister to appoint so-and-so is not the abuse of the system by the minister. It is in fact allowed by the minister by the Public Service Act, and that is what is changing. So actually the reform of the Public Service Act is going to be a major constraint on cadre deployment, not just by the ANC, but by any political party. And in that regard, I think it's the beginnings of a very progressive development within South Africa. I would think it's within government, I think it's probably the most important reform since 1994, actually.
Yeah. Just finally also, what would you say the priority of the state should be once this law has been enacted? What's the first thing that should happen? And I ask this also on the basis of we have an election that is coming up. Not too sure whether the NCOP will be able to pass through this legislation and then be enacted by the president. But if that does happen, what should the immediate priority be for the 7th administration?
So it's an interesting question about why suddenly now. I mean, the truth is, some of us have been working on these questions now for years and years and years. It's only recently that it's gained momentum. And then even, this is a piece of legislation that's been in Parliament since the beginning of early last year, and it's only now that it's gaining in momentum. So it's an interesting question about why now is it being taken up. I suspect that there's a sudden urgency in the ANC and in government about passing it. So I suspect actually that it's going to get through the NCOP and will be potentially be signed off by the president before the election. That's my gut instinct. And I think there's some interesting questions about why there's some urgency. I suspect that it's a sign that President Ramaphosa might see this as his legacy issue. He can leave. His presidency, I think, is widely regarded as a failure in all sorts of respects. But this could be a major legacy issue of modernizing the state, of leaving as one of his legacies is a modern professional public service. The other one is I suspect as well that the ANC are concerned that they are going to lose power in key areas and that they are worried about the possibility of opposition parties having the kind of discretion which they've enjoyed for nearly the last 30 years in key departments. I suspect that that's what's driving it. So in terms of what urgency, unfortunately, this is not a silver bullet, so it's not going to instantly transform the way government works. I think it's a profound step. I think the next step is around professionalizing the public service, which is around there's a current framework. I think it's got some really great things in it around the professionalization framework. So I think the urgency then is around starting to implement it. And in particular, now that politicians can't control who gets appointed to the public service, and now that responsibility largely falls to director generals and heads of departments, we need to make sure that the kinds of people coming into the public service are the right kind of people, suitably qualified, the right kind of ethics, the right kind of approach to government, an understanding of their role as public servants, not as political servants. So I think that piece of the puzzle is absolutely fundamental going forward.
Thank you so much for your time. That is Dr. Ivor Chipkin, who is Executive Director of the New South Institute on the recent Public Service Amendment Bill that has been passed by the National Assembly.